Hello, we are back with another video report on the DHFL scam. This time, it will be on the role of the RBI-appointed CoC for DHFL, or the Committee of Creditors for DHFL, which was employed to carry out a litmus test of the IBC 2016, or as the RBI called it, as a test case for the IBC, for legitimizing the IBC through the scapegoating of the DHFL victims as laboratory guinea pigs. Now, the IBC, Insolvency and Bankruptcy Code, is an ill-conceived code that has been amended multiple times over the course of merely 8 years. Moreover, the DHFL itself was not supposed to go into the IBC since it was an ongoing profitable solvent AAA rated NBFC or non-banking financial company which did not stop meeting its payment obligations to its FD and NCD holders until the Bombay High Court stepped in September-October 2019 and stopped all those payments in response to the case filed by Reliance Nippon Life Insurance. Now, the DHFL CoC did not heed the FD holders' legitimate full repayment claims despite multiple lines of questioning and demanding. The CoC also did not allow the erstwhile promoters, the Wadhwan brothers of DHFL, to take part in the resolution process. They did not even bother to consider the Wadhwan brothers' full repayment proposals, which were repeated multiple times. It is also to be duly noted that they were not allowed to participate in the DHFL CoC's resolution process, its meetings, following the IBC section 29A, which is a very controversial section in the code and has been amended quite a couple of times. Now, the Honorable NCLT, we have to remember, the Honorable NCLT in New Delhi declared that the suspended director who was representing the corporate debtor and has submitted the settlement proposal is entitled to participate in deliberation and negotiation undertaken by the CoC. This statement was made by the NCLT New Delhi bench in the case of Sanjeev Mahajan versus Indian Bank. But in the DHFL case, this did not happen. Now, why did Mrs. Charu Sandeep Desai, the so-called representative of the public depositors, indefinitely postpone the DHFL bankruptcy process in the course of multiple 20 plus CoC meetings by consuming expensive money without helping the DHFL fixed deposit holders to get their lifetime savings back? The RBI-appointed CoC administrator R. Subramania Kumar and the representative of the FD holders had swallowed the DHFL victims' money to continue the expensive resolution process from 2019 to 2021. Now, if R. Subramania Kumar and Charu Sandeep Desai are ever sued by the DHFL victims for this, they would fight against the victims themselves by utilizing their money. As public servants, what they have done is probably a case of legal conflict. Why they are being called public servants will be clear consequently. Therefore, the DHFL victims also had requested R. Subramania Kumar as well as Charu Sandeep Desai to return their fees as taken by the RBI appointed CoC. Now, to the question of why a resolution professional is a public servant, we have to say, following the Section 2C of the Prevention of Corruption Act 1988 and Section 233 of the IBC, these do not protect where the resolution professional has been apprehended red-handed with the bribe amount. This was observed in the case of Sanjeev Kumar Agarwal versus Central Bureau of Investigation, Anti-Corruption Bureau, Dhanbad. The entire resolution process of the DHFL was carried out by the CoC from 2019 to 2021 and seemed to favor Mr. Ajay Piramal over other competing bidders such as Oaktree Capitals, Adani Group, etc. Adani left the bidding process, perhaps anticipating the nuisances of the bumpy legal hurdles that lie ahead. Oaktree alleged bias of the CoC in favor of Piramal. Was this not due to Piramal's close tie-up with the BJP? Of course, it seems to be the case. We now have to talk of the controversial NCLT verdict of 19th May 2021, which ordered the CoC to reconsider the full repayment proposal of the erstwhile directors of DHFL, the Vadhavan administration, which was left unheard. The NCLT verdict also said to keep the DHFL as an ongoing concern. But the Piramal and the CoC got the order revoked within days at the NCLT on 25th May 2021 without answering the NCLT's pertinent questions within the stipulated time period of 10 days. Whether the same can be admitted as a contempt of court or not requires urgent judicial attention. Mr. Ajay Piramal thus presumably violated Article 215 of the Indian Constitution. The CoC in fact said in response to this NCLT verdict that if the DHFL was not made an experimental subject of the IBC masterminded by the BJP and sent to the CIRP, the Corporate Insolvency Resolution Process for insolvency, and if this controversial NCLT order was given its way, then it would set up a bad precedent. Whether good or bad, we must call spade a spade. The NCLT, consequently, was forced to approve the resolution plan on 7 June 2021. Piramal then acquired, quote-unquote, the DHFL in September 2021, and that was simply on the basis of the lowest quasi-judicial body NCLT's verdict. And it gave huge haircuts to the FD and NCD holders' principal amount. Now we have to move on. We have to talk about the most significant verdict, the NCLT verdict on 27 January 2022 in response to 633 Moons Technologies' case that designated the CoC resolution process to be contrary to law with material irregularities in the exercise of the powers of the resolution professional, void ab initio, as well as it pointed out the question of section 66. It was in fact pointed out by 633 Moons itself, which said that section 66 of the IBC provides for the benefit of all the creditors without any discrimination or hierarchization. This NCLT verdict that I am talking about was stayed by the Supreme Court on 11th April 2022 after Mr. Piramal again approached it as a habitual stay order seeker on 1st March 2022. This stay order given by the Supreme Court was simply a temporary partial ex parte stay and not a blanket stay order, it must be reminded. But the question remains. The question remains as to how the NCLT first order on May 2021 and the NCLT second order on 27 Jan 2022 are to be revisited and used as weapons at the disposal of the DHFL victims by choosing out the specific portions from both these orders in order to defend our cause, our case, in order to make our case before the concerned authorities. Yes, Piramal, like an impossible, in terms of an impossible arithmetic, a strange arithmetic, bought the DHFL's 45k crore assets for only a rupee. and we have to challenge it at every step that we can. And we can challenge it, in fact, through these court verdicts. These cannot be ignored. These are in our favor. But it all depends on the political will. And now the political will has been severely dealt with after the 4th June election verdict. We can talk about our rights, business-related rights, as recognized by the United Nations Guiding Principles on Business and Human Rights, since this is a case of financial abuse by a CoC that had certain predetermined goals, maybe predetermined, most probably predetermined by the BJP and its associates. So, let us not hesitate, let us not question ourselves, but question our identified enemies in this context. Thank you. We'll be back with another video very soon on this channel. But before turning off the camera and clicking the pause button on my video recorder, I must request all those who are watching this video to kindly like, comment, subscribe our channel and all our videos, and please share it amongst your relatives and friends for wider circulation, so that every deaf authority can hear our voices, and it takes a loud voice to make the deaf hear. Thank you. We'll meet again soon.